What is your name, please?
My true name or the name you have on file?
Either one.
True name, Love Sherman Tucker II. Name on file, Langston D. Arrington Copeland.
A routine court hearing quickly turns into a fascinating courtroom exchange when a defendant challenges nearly every step of the process. As the judge carefully explains a complex legal agreement, questions about rights, contracts, and court authority create a tense back and forth. Will the defendant accept the deal, or will this hearing take an unexpected turn?
View that option. There are two matters that are before the court involving Mr. Arrington Copeland today, 26L000032 and 26L000304. Each of these two matters are before the court for pretrial conference. Mr. Larson, good morning. How would you like to proceed with the pretrial conferences?
Good morning, Your Honor, and for the record, Attorney Drew Larson here with Mr. Arrington Copeland, who is appearing via Zoom. Your Honor, parties wish to enter into a stipulated order of continuance today, and I've uploaded that to O Courts. Your Honor, I've reviewed the documents and collateral consequences with Mr. Arrington Copeland. Mr. Arrington Copeland understands that this is an agreement between him and the city. He understands that by entering into this agreement, he is giving up many important rights. Mr. Arrington Copeland understands...
I overstand. I don't stand under anybody.
Mr. Arrington Copeland understands that in order to benefit from this agreement, he must abide by certain conditions. Your Honor, this is a 24-month stipulated order of continuance. Pursuant to the stipulated order of continuance, Mr. Arrington Copeland is required to obtain a mental health evaluation and receive any recommended treatment under said evaluation. He is also to abide by the active protection order issued out of Pierce County Superior Court, and he is to have no new criminal law violations, Your Honor. Mr. Arrington Copeland understands that if he violates the terms of this agreement, the court can read the police report and find him guilty of the charged crime without trial. Mr. Arrington Copeland is stipulating to the admissibility and sufficiency of the facts in the police report to find him guilty. Mr. Arrington Copeland understands the maximum sentences that could be imposed on these charges if the agreement is revoked. Ultimately, Your Honor, I do believe that Mr. Arrington Copeland is entering into this agreement freely, knowingly, and voluntarily. Thank you.
Thank you, Mr. Larson. Mr. Arrington Copeland, I show that your date of birth is December 30th, 1988. Is that correct?
Indeed.
Mr. Arrington Copeland, I have in front of me a document entitled Stipulated Order of Continuance encompassing both of these cases. Have you reviewed this document in its entirety with your attorney?
Indeed.
Mr. Arrington Copeland, for all intents and purposes, this stipulated order of continuance is a contract that you're asking to enter into with the prosecution to resolve these two cases. Is that your understanding as well?
That was to my understanding, it's a stipulation or a contract that I was offered. I didn't ask for anything. I asked for a civil standby because I don't have any interest in dealing with this woman anymore. If it is all right, I'd like to address the court formally.
Mr. Arrington Copeland, what I'm trying to determine right now is whether or not you are asking to enter into this stipulated order of continuance agreement with the prosecution in these two cases. Is that how you're asking to proceed this morning?
Indeed. Go ahead.
Yeah, Mr. Arrington Copeland, as we discussed, the protection order is issued out of a different court, and I've sent you an email with more information on how we can get that addressed, but this court is not the proper venue to address the underlying protection order.
Indeed.
Mr. Arrington Copeland, do you understand that?
I understand that you guys have to do your job, so yeah.
Well, and it's also important to me that you understand what Mr. Larson just said, which is there is a valid no contact order that has been issued in which you are the restrained party, but that was issued by Pierce County Superior Court because that's a different court. I don't have the authority to change or create any exceptions to that order. That's something you'd have to take up with that court. Okay?
That's fine. So I have a simple question. Upon release, if I go to Lakewood PD, can I have them take me there so that I can gather my things? Because at this point, I have nothing. She left me with nothing. She has my identification in that location. I have no way.
Mr. Arrington Copeland, I've sent you an email with detailed instructions on how you can request a civil standby, but that has to be done through the Pierce County.
Larson, she has my EBT card. I have no way to feed myself. If that's the case, then I'll just stay in jail. I got 3 hots and a cot here.
Mr. Arrington Copeland, I've sent you an email. It'll be ready for you upon your release. That'll detail how you can get your wallet back, okay?
And Your Honor, the city has had an opportunity to reach out to the victim. It's my understanding that his wallet is waiting for him at the Lakewood PD.
Oh, okay. That's very helpful. Thank you, Mr. Tuninga. So, Mr. Arrington Copeland, it sounds as if your wallet, which hopefully does contain your EBT card, has been taken and provided to the Lakewood Police Department. So you can swing by the Lakewood Police Department upon your release and pick that up.
Yeah.
Okay.
Indeed.
So, Mr. Arrington Copeland, what I need to know is, and you answered this question a moment ago, that you understand that this is a contract between you and the prosecution, and that this is how you're asking to proceed today. Have you gone through this document in its entirety with Mr. Larson or one of his colleagues?
Indeed.
Okay. Have they answered all of your questions about the terms and conditions of this agreement?
Indeed. I only have one other question. What's the consequences, I guess?
We're going to get to that. We're going to go over that right now. But what I wanted to make sure of is that you've reviewed this document with your attorneys.
Indeed.
Okay. So, Mr. Arrington Copeland, by entering into this agreement, you are waiving a number of your constitutional rights, including your right to a speedy jury trial. Do you understand that?
Indeed.
Okay. It appears that this is an agreement for a period of 24 months or 2 years. If you fully comply with this agreement, after 2 years, the prosecution has agreed to file a motion to dismiss both of these cases. But in order for you to receive that benefit, you are agreeing to do a number of things over the next 2 years, and I want to review those conditions with you at this time. You are agreeing to appear on time for all scheduled court hearings. You are agreeing to have no violations of the criminal law. You are agreeing to keep the court updated as to what your best mailing address is. You are agreeing to obtain a mental health evaluation from a state certified agency such as Greater Lakes and file a copy of that evaluation with this court within the next 60 days. And then within the next 90 days, you are agreeing that you will be engaging in any counseling or treatment that evaluation recommends and will participate in and complete that treatment. And that proof will be filed with the court. Is that your understanding, Mr. Arrington Copeland, of what you have agreed to do in order to receive the benefit of this stipulated order of continuance agreement?
Yeah, under maritime law, yeah.
Could you say that last part again?
Under maritime law, yes.
Okay. But you understand that regardless of the body of law that is applied here, you understand what you're agreeing to do under this contract, correct?
Correct.
Okay.
This is where the hearing takes a surprising turn. Just as the judge outlines the conditions required to dismiss all charges, the defendant suddenly brings up maritime law. Rather than reacting emotionally, the judge stays composed and redirects the conversation back to the agreement itself. Would you have had the patience to handle this situation the same way?
4 months, this court were to conclude that you had violated any aspect of this agreement or not fulfilled any of your obligations under this agreement.
Please review them with me.
Okay, but have the two of you discussed what would happen?
We discussed briefly.
I'm sorry?
I want to hear from you, though.
Say that again.
I said we discussed briefly, but I want to hear from you.
Okay, I'm going to go ahead and review that with you. So the bottom line is, if at any point in time in the next 24 months, the motion to revoke this agreement on the basis that you had not complied with any aspect of this agreement, the court would consider the evidence and determine if it is more likely than not that you have failed to comply with any condition or violated any condition of this agreement. If I concluded that it was more likely than not that you'd violated any aspect of this agreement, I would in all likelihood grant the prosecution's motion to revoke. Now, if that were to happen, the next thing this court would do is would conduct a bench trial to determine whether or not you are guilty or not guilty of 2 counts of domestic violence court order violation and 1 count of criminal trespass in the first degree domestic violence. It's very important that you understand, Mr. Arrington Copeland, all 3 of those charges are gross misdemeanor offenses. They are punishable by up to 364 days in jail and a $5,000 fine on each charge. And because they are crimes involving allegations that they are domestic violence related offenses, the court can take up to 5 years of jurisdiction if you're found guilty. The other part that you need to make sure you understand very clearly with this is if that were to happen, if this court were to revoke the agreement and proceed to a bench trial on these 3 charges, the only evidence the court's going to consider in determining whether or not you are guilty or not guilty is the police reports of the investigating police officers. And you are stipulating that that is admissible evidence and is the only evidence that I will consider at that bench trial. Do you understand all of that?
Indeed.
Okay. And this is still how you want to proceed with resolving both of these cases here today?
I have a question.
Go ahead.
So, I need help understanding something right now. How is a order filed out of Tacoma being prosecuted in Lakewood and upheld? That doesn't make sense to me.
Sure, that's a fair question. So remember that the court that issued the no contact order, that is the basis for 2 of these 3 criminal charges, that is a superior court of the state of Washington. Now that particular superior court is for Pierce County and it sits in downtown Tacoma. But they have jurisdiction as judicial officers in Superior Court over the entire state of Washington. Okay, so their orders are enforceable anywhere in the state of Washington, including the city of Lakewood. Further, it's also important, since you asked the question, remember that a Superior Court judge of a state in the state of Washington is their orders are entitled to what's called full faith and credit under the United States Constitution, and also a federal law called the Violence Against Women's Act. Now, I point that out to you because I want to make sure you understand that order, you could be in Florida. And if you violated that order in Florida, you could be arrested and prosecuted by authorities in Florida, because each and every state is required to give full faith and credit to the judicial orders of judges in other states. So this no contact order as long as it remains valid, and you can always go back to the Superior Court and ask them to change it or cancel it, but as long as it remains valid, it is enforceable throughout the United States of America.
Now the courtroom reaches its most educational moment. The defendant questions how an order issued in Tacoma can be enforced elsewhere. The judge responds with a detailed explanation of jurisdiction, constitutional authority, and interstate enforcement. Instead of escalating the disagreement, the court turns confusion into a lesson on how legal orders work across the country.
After 24 months, if you've done everything that this agreement requires of you, the prosecutor has agreed their end of the bargain. They have agreed that if Mr. Arrington Copeland does everything he's agreed to, they will bring a motion to dismiss all 3 charges. And then everything will be dropped. But you've got things that you are required to do in order to receive that benefit, and it's going to have to take 2 years before the prosecutor does it.
Can the prosecution explain to me why I need to take a mental health evaluation?
I don't think the prosecution is going to explain anything here, Mr. Arrington Copeland. The way it works is the prosecutor speaks directly with your attorney who negotiates on your behalf. The prosecutor almost never speaks directly to individuals who are charged with a crime because he doesn't want to infringe upon your right to have an attorney represent you.
Indeed. All right, we're good.
Okay. Do you have any other questions about this stipulated order of continuance agreement?
No, I'll talk to my lawyer about it.
Okay. So, Mr. Arrington Copeland, the last question I asked you that you still haven't answered, I asked if this is how you want to resolve all 3 of these charges with this agreement today. Is this how you want to proceed?
Indeed.
Okay. Mr. Larson, I have spoken with your client extensively, probably more than I do most defendants in a stipulated order of continuance. So I'm going to give you the last word here before the court makes a final determination. Mr. Larson, are you aware of any reason that this court should not accept entry of this stipulated order of continuance agreement as requested by your client?
No, Your Honor, and I would just note for the record that this was an extensively negotiated resolution here today between the defense and the prosecution. I have had extensive communications with Mr. Arrington Copeland regarding the stipulated order of continuance, and I am happily available to Mr. Arrington Copeland in the future, should he have any questions regarding what he needs to be doing under this contract. I've already provided Mr. Arrington Copeland with an email dealing with sort of next steps on things that he needs to be doing upon his release as well, Your Honor.
And based upon your conversations with Mr. Arrington Copeland, you are satisfied that your client understands this agreement in its entirety, his obligations under this agreement, and the potential consequences he would face were he to be found in the next 2 years at any point to have violated this agreement?
I do believe he understands, Your Honor.
Okay. Based upon that record, the court is going to accept entry of the stipulated order of continuance agreement that has been negotiated between the parties in this matter. The court is satisfied, based on my conversation with Mr. Arrington Copeland this morning, that he understands the terms and conditions of this agreement and that he's entering into it knowingly, intelligently, and voluntarily. That is also bolstered by the 2 records that Mr. Larson has made regarding his communications with his client concerning the terms and conditions of this agreement. The court believes that Mr. Arrington Copeland understands the rights that he is waiving by entering into this agreement with the prosecution, the terms and conditions that he must satisfy in order to receive the benefit of this agreement, as well as the potential consequences that he would face and the procedure this court would follow in the event that the court were to conclude any time during the next 24 months that he had not fully complied with this agreement. The court is setting a final review in this matter for February 17th, 2028 at 9 a.m. Court is going to waive Mr. Arrington Copeland's presence at that final review hearing if the parties are in agreement that he is in full compliance with all of the terms and conditions of this agreement prior to that hearing date. One question that I have for Mr. Tuanenga and for Mr. Larson, there is an affirmative condition as part of this stipulated order of continuance that we have discussed, the mental health evaluation and compliance with any recommended treatment. The parties have negotiated the evaluation to be filed with the court within 60 days and for any recommended treatment to commence within 90 days. Are the parties requesting an intervening hearing to review whether or not that condition is being complied with?
That would be city's request, Your Honor.
Defense would defer to the court on that issue, Your Honor.
I think that's appropriate. I'm going to ask one of the attorneys to load a notice of hearing. The court clerk is going to do that for me. The parties have negotiated a timeline for the evaluation of 60 days in compliance with recommended treatment within 90 days. So the court's inclination at this point is to set a review in approximately 120 days. The court's going to set that for July 9th, 2026 at 10 a.m. Court is going to waive Mr. Arrington Copeland's presence at that hearing if before that hearing the court has received documentation verifying that he has completed the mental health evaluation. And Mr. Larson, have you discussed with Mr. Arrington Copeland where he can go to get that mental health evaluation?
Yes, Your Honor. I've provided an email to Mr. Arrington Copeland detailing 3 or 4 locations in the Lakewood, Tacoma area where he can get that done.
Thank you. And then the court's also going to be looking for documentation verifying that Mr. Arrington Copeland has begun participating in complying with any treatment that's recommended in that evaluation. If the court has received documentation verifying compliance and Mr. Arrington Copeland is otherwise in full compliance with all of the other terms and conditions, his presence at the hearing on July 9th is also waived. Otherwise, he will need to be here. Okay, that I believe will conclude Mr. Arrington Copeland's 2 hearings. Mr. Arrington Copeland, you should be released sometime in the next few hours. If you have any questions or you need any help following through and completing the terms of this agreement, please make sure that you reach out to your attorney so that they can advise you on how to proceed, okay?
Yeah.
All right, Mr.
In the end, patience, professionalism, and clear communication guided this hearing to a resolution. The judge ensured the defendant understood every condition before accepting the agreement, turning a potentially difficult proceeding into a lesson on courtroom procedure. If you enjoyed this courtroom breakdown, leave a comment, hit like, and subscribe for more real judge and court moments.